Уважаемые дамы и господа.
Ladies and gentlemen, we're starting the roundtable discussion on antitrust regulation in the global economy, experience of Russia and elsewhere. It's a pleasure that as part of this high-standing legal forum, we have a separate roundtable discussion dedicated to anti-monopoly legislation, which is caused by the fact, I think, that antitrust legislation in today's Russia is an important area in the legal profession. And what we're going to say today about that will be another evidence of a lot of attention being paid to this sector of the nascent legislation in Russia. There's been a lot of problems in this area that we try to address through development of enforcement, establishing new legal institutions, and the discussion we should have here should become one more step forward to improve and promote antitrust regulation in Russia in the globalization context, and as we collaborate with our counterparts in other parts of the world. And our conclusions, let's hope, will be very helpful for doing that. Let me introduce our distinguished panelists who will speak on the antitrust topics. Igor Yuryevich Artemyev, who is head of the Federal Anti-Monopoly Service of the Russian Federation. He's been at the head of that since 2004. He's greatly experienced in antitrust regulation, and he's an honorary economist of the Russian Federation. Our next speaker will be Mr. Alda Bergenov, who is a board member of the Eurasian Economic Commission, the rank of a minister, on competition and anti-monopoly regulation. Mr. Alda Bergenov is also greatly experienced in antitrust regulation. He has done natural monopolies, and our next speaker will be Theodor Tanner, who is Director General for the Federal Austrian Competition Authority. He has got a lot of practical experience in antitrust regulation in the European Union, and the practices he will share should be very interesting, I believe. Oksana Yurievna Gvozdilina, judge of the Supreme Arbitration Court. She specializes in cases relating to competition or antitrust-related issues, and she is greatly experienced in considering such cases at arbitration. Another speaker will be Michael Granfell, who is partner for Norton Rose LLP, and he is an expert in antitrust practices. Next will be James Flynn, who is the royal lawyer, greatly experienced in antitrust matters, and he will share British experience. And finally, we will listen to Yevgeny Voyevodin, who is a practicing expert in antitrust regulation, and he's head of the General Counsel for the non-for-profit partnership competition promotion, associating leading lawyers and economists. Once this introduction is over, let me give the floor to our first presentation to Mr. Igor Yuryevich Artemyev, who will outline the key principles of today's antitrust policy in Russia, and he will tell us about the problems Russia is facing as it integrates with other antitrust jurisdictions and the ways of addressing them. Igor Yuryevich, you have the floor. Thank you very much, Sergei Anatolyevich. Good morning, ladies and gentlemen. Yesterday, well, the plenary discussion was rather generic, of a rather philosophic character, and it was very open and sincere, which I liked very much. And since this audience is very sophisticated. It might hardly make sense to tell you about the norms of law and our enforcement plans. I should only mention it in passing closer to the end of my talk. I'd better make some conclusions about the mission we've been up to for years. I've been trying to do that for 8 years. There's a lot of philosophical considerations about what we do, and there are whole entire areas of legal thought. So libertarians are do not like antitrust policy at all, but many people talk about the invisible hand of the market, which should correct all things through invisible feedback and competition, through self-regulated organizations to improve the economic life for the better. Well, the more I have considered myself a liberal all my life, including in the economics, and the more I listen to that, the more I know about the situation with the monopolies and their practices, bad policies, the less trust I have in the invisible hand of the market. It's important to remember that the state should use all elements of its existence to maintain certain rules in place, sometimes making people to move towards best practices. Maybe in other countries where the judiciary has been there for centuries with well-developed parliamentarism in place. It was all done much earlier, and they don't face as much problem as we do. But the more cases I read, the more I'm certain that large and largest companies do not behave fairly at all. Whenever they have an opportunity of grasping another lucrative bite of anything, they will always do that without paying much attention to somebody else's rights. So to the extent that this economy is a monopolistic economy, to the same degree we shouldn't be talking about the invisible market hand. And it's not only that we shouldn't talk about that, it is dangerous talking about that. The civil society in this country is still very weak, and the state is the only force around who can really bring to order those who violate ethical, economic, and legal norms. So my first conclusion is this. General assumptions that I mentioned in the beginning do not work here in Russia. You must have a legal framework, federal legislation in place that would restrict and restrain bad practices of monopolies, and we're lucky to have such a legislation in place, at least in its initial form. Otherwise, we would have been back to the early 90s with its rogue capitalism. My second conclusion is that, which I think is the most important, Russian companies are ready to follow strict rules. Those could be very strict. They could be as strict, close to strict rules that the European Union or the US have. But the companies say, we're only ready to follow the rules if there is a level playing ground, because we are afraid, they say, those rules would be used for unfair competition. We are afraid of selective enforcement, and such examples are not few. And we at the Anti-Monopoly Service know that. So as we hear that we shouldn't develop legislation further, we shouldn't impose these big fines, why don't we reduce the size of fines? Why don't we take criminal liability away? But that's a way towards nowhere. If competitors and businessmen do not realize that unfair conduct should not make you successful, while unfair conduct is something to make you successful many times. It is a competitive advantages, unless this is countered with strict sanctions. We won't have a good economy and society, and the rules will only be respected by the society and the businesses if we don't have any selective enforcement. Again, Dmitry Medvedev yesterday mentioned the open government when it comes to civil institutions. We ourselves should not turn into an instrument of selective enforcement, and the freedom of the press must be there for that, and well-developed civil society which should have a lot of rights to supervise over what is going on. Of course, you need the judiciary, of course, but I'm not talking about the elements of the state now. Independent reports must be prepared by the civil society and independent professionals, describing what was good, what is good or bad in the practices of businesses and the government, with also describing good and bad practices in every respect. Another point of our opponents is that allegedly an anti-monopoly body, which is legally important to say, what it does is actually redistributing values from large companies who are violators towards smaller businesses. So actually taking protectionist measures to protect small or medium-sized businesses who are not able to do anything. And this redistribution from the big ones to the smaller ones is a sort of protectionist policy of the state which hinders the progress, because our opponents say that only large companies have enough strength or capacity or resources to attract, to hire best brains, invent innovative technologies and the like. This is one important thing to mention here. We do not redistribute anything. We just restore rights that were violated before. As a company, a big company, puts all its weight, market weight, on a smaller company, dominating it or suppressing it, sometimes using the government, we actually do not redistribute anything for the benefit of the smaller company. We just rescue it. We restore the lawful rights of people who have the right to do business. And you shouldn't confuse redistribution and protection of legal rights. That's another important thing, why our effort in this regard is really important in the legal terms. In other words, I'm not a strong believer, actually, that the business will evolve itself towards best practices. Competitive technologies, yes, that could be done, but when it comes to expansion or gentlemanlike behavior, no. What we saw in the 90s was a serious foundation that must be overcome with time, because many practices were established that were not very good when people fought in the competitive competition, sometimes using the government and its mechanisms. The government itself creates quite a good legislation, in my view, in our area, providing a lot of capacity to protect the rights of the businesses. Parallel to that, there are quite a few government officials who are currently official ambassadors of businesses to the state. They actually serve for the best interests of certain businesses. And it would be difficult to imagine ourselves at the anti-monopoly service if we didn't see that almost every day. And about half of our efforts go for fighting the government mechanism itself, government machinery itself, promoting unfair competition on behalf of the state. That's why the anti-monopoly service is one of the few institutions that is entitled to pursue people, including government officials. For companies, we can apply large sanctions, and the prohibitive size of those can make companies change their behavior, while the maximum fine against the individuals is 50,000 rubles. And there was a recent provision for the possibility of disqualifying. And this year we will try to file some lawsuits this year to disqualify not only corporate managers, but we will necessarily try to do that against government officials, because the merger of the government machinery and certain businesses in order to gain unfair advantages, that is the most dangerous situation altogether, because fighting the state is very difficult, you know. You must have a very clear-cut policy. We have such a policy in place at the philosophical level, but because of too high corruption, it has little impacted the government machinery so far. Actually, if we asked 100 top managers or leaders in this country what they think about competition, the 100% hit would be everybody's in favor of competition. But as we start to analyze the mentality of decision makers today, we would find very few people, very few politicians or decision makers who would be willing to opt for competition every day, allowing more and more companies into the market to compete with each other, to be more open and more transparent when having tenders for mineral resources, who are ready to have a dialogue with the civil society, answering not always pleasant questions. Since the Soviet times, the only thing many people have thought that the economy of scale could play the trick just alone. If you pool all assets into one company, the United Aircraft Company, that's the only corporation in Russia who does that. We have the United Shipbuilding Corporation, the only big corporation in Russia who makes ships in this country, and we see a similar picture in many, many sectors here, not because of the crisis, but mainly because of the situation that had emerged in the 90s, a pretext of rescuing those enterprises. Efforts were applied to monopolize those sectors, successful efforts. It could be tolerable for a short while after the collapse of the 90s, but by now it has turned into a real hindrance. And we need to do demonopolization of entire sectors. I only mentioned two of them, but there's a dozen. Many important events. An important event was the creation of the Eurasian Commission. Well-known models of development that were accepted in Europe when building the European Union and when building the anti-monopoly bodies of Europe. And we see before our eyes, and in the presence of our respectable colleagues, Minister Aldebergenov, who heads this for Russia, Belarus, and Kazakhstan, having that commission in place is very important, and every year it will be more and more important within this space. And what best we can take from Russia, Kazakhstan, or Belarus, we should use it as a legacy, but we should drop the legacy that is not good, at least at the government level. We can do it at the legislative level. Mr. Aldebergenov's idea that we should have the antitrust code for the three nations, a single code for the three countries, although the current codes are quite close one to the other. And I think that idea is really brilliant. It is because among other things, because the legal community and people who maybe not present here today, those are exactly the people who should do the job. For your information, we've looked at the three codes, and there are no big discrepancies there. Much has been done already, but that will be very important, politically included. And finally, I'd like to say that today the state has created good prerequisites for advancing forward. We think that anti-monopoly rules are like rules of conduct in the society, or the navigation rules. and the basis of future economic success. If the navigator, if this economic GPS works properly, if the government lubricates all the mechanisms, and if it stops all attempts to abuse, we will have a good economic system in place. Good conduct should be based on good rules. As regards enforcement, we have seen a lot of problems. It is now better than it was, say, 10 years ago, much better, I would say. Still, we have not got rid of selective enforcement and government protectionism and many things where corruption is the underlying factor. Until and unless we can fight corruption with force, we will be doomed for anti-competitive movement without any progress, and we must be very transparent and open as we talk about that. It goes beyond the anti-monopoly sector, but it is still close to this because the anti-monopoly legislation implies transparency and limiting discretion of many important persons, including government officials. Let me thank now the organizers of this forum. It's always a pleasure for me to be in my native city of St. Petersburg. We've been lucky with the weather so far. So once this is over, I hope you will all be happy. Thank you. Thank you very much, Igor Yurievich. We will take questions after having listened to all presentations, and after Igor Yurievich's description of all issues. First of all, transformation and active integration of the Russian Federation and our closest neighboring countries, Belarus and Kazakhstan, with shaping the single economic space. That is, from our perspective, our perspective, that is the most relevant thing to discuss. Given our little experience, only 20 years experience, but still quite rich in terms of the number of cases and examples, we hope we can, without this, it would be impossible to organize efficient collaboration within the customs union. So the opinion of the respectable minister, Mr. Aldabergenov's opinion will be very important about the regulation to be done as part of the Eurasian Commission. You have the floor.
Belarus as well as for Kazakhstan. Only in the last year, the increase of the turnover with Belarus increased by 137%, and with Kazakhstan it's over 60%. At the end of the last year, there was a decision taken by about the establishment of the Eurasian Commission. It is a permanent body which based on the harmonization of the national legislation. Since we don't have any borders, our field of activity is open and all the transfers are free. And so, first of all, this the harmonization. We are successfully conducting this work, and I don't think that we have any significant differences in this field. And so the main principles that we are operating in our countries, they are practically the same. And I think that we are successfully undergoing this stage. So as a number of authorities will be transferred to the Commission, there will be some matters of dispute, but now we have this above the body which works above the national government. We are based in Moscow, but if we have any dispute, we go to a beautiful state, to the capital of Belarus, to Minsk, and we discuss all these issues there. A very important issue, what will be this commission working with, and what will be the subjects that they're working with. And I want to stop at the main moments. First of all, the infringements, the violations which reflect on the national level. And of course, these are the services of telecommunication, aviation, main raw markets, oil, carbon, because in Russia and in Kazakhstan we have many joint ventures on elaboration of different goods and supply of carbon. And so, well, this sector is also under our umbrella. The markets of metallurgy, it is important not to avoid the violations which may negatively reflect on the competition of two or more countries. What are we doing now? Now we are cooperating with the respective authorities, and at the moment we are participating in the meetings of the Euro-Asian Commission, and they participate as observers in the investigations which are investigated by the national government. So we are served as experts. As experts, we are coordinating the work and we provide our recommendation. This period embraces practically 1 year, and I think that in future, after some regulatory documents will have been approved, we will work together very often. Sometimes we face a question about the details of this work, and I think that we will stick to the position that we will work together with the national governments, with the national bodies. The main work which will be dedicated to the investigation of the violations of the antitrust legislation will be done together with the national bodies, and if it concerns two or more countries, then all together we will take a joint mutual decision. We will work as a whole. And very often we are being asked questions that national bodies are not participating in this business, but I don't think that this is admittable. We have to work together, and the main purpose, the main goal, that all the commodities, all the markets should be transferred free without any violations of the national legislation. What are the first and foremost tasks in front of us? Until the end of this year, we will have to, and we are conducting a tremendous job in this direction, and I should like to thank the Antitrust Service. I should like to extend my thanks to them. We have daily, weekly meetings so that to expedite this work, and we have to approve the criteria of the market, and also we have to approve a number of the regulatory documents. It is the method of assessment, it is the high prices, it is the investigation. I don't want to stop at these questions, but until the end of the year, we have a calendar, and we will be able to approve all these documents. In the first stage, we have to approve the model legislation so that these three states, three governments, they should focus on this model legislation since we don't have any borders. So this model of legislation should not be qualified as the national legislation. We have to bring all these questions to a unique conclusion. This is the main task for us, is to approve the model legislation. Then the matters of perspective. Again, I should like to repeat that since the borders are open, we need a kind of a code. And thanks to the Antitrust Service, because they supported this idea, we are working with them very closely, and in the very near future we have to establish a unique code with regard to the antitrust monopoly. And we do have a code of the customs code, we have the taxation code, and I think that if we succeed, we will provide a tremendous support to our business. And since there is a free movement, no borders, no customs, no checks, in this space we are moving quite free, and whether you live in Belarus, you either provide your services to the territory of Russia or Kazakhstan. We need to have a unique regulatory document, and using this document, people can move and act. I think this is a very important task, and we will be able to solve this issue. The direction, the trend that we are working on, in addition to the antitrust monopoly, it is the price fixing, and it is an individual section, and we need to establish a concept towards the antitrust monopoly. Price fixing is a very important question for us. It is like a constituent part of the competition policy, and I think that in the near future, when we will be approving this concept, we will deliver more details to you. Then the public procurement. In this field, we have a progress experience of the Russian Federation. The Federal Anti-Monopoly Service is doing this work, and we think that together with the joint efforts, we will achieve the target so that every citizen or every subject of this or that country could participate in the auction, in the competition. I think it will be an excellent solution for us, for all of us, because we will be able to avoid corruption. We will have the accessibility, and whether you stay in Kiev, you may participate in all the auctions in Kazakhstan or in Vladivostok. This is the very important task for us as far as the public procurements are concerned. And it is included in our plan. In the near 2 years, we will have to solve all these issues. We still have some questions pending decision, but I think that they will find this decision. Dear colleagues, this was very brief. I delivered my report on all the tasks that we have in front of the Euro-Asian Commission. We have some issues, but we will be able to solve them with the help of the national bodies. And the final result is the result of the consumers, of our citizens, because they will move free and having a competition right. Thank you very much, Nurlan Sharibekovich. Yes, it is true that the problem of integration and formation of a national body is a matter that we have to respond in the very near future. We have to allocate the duties, for the national bodies, for the bodies which work above the national body. We have to avoid the conflicts. We have to set up the organization, and everything will depend on the correct organization, because this is the pledge for success. And we have to follow the example of the European Council, European Union. And thanks to the visit of Theodor Tanner, Mr. Tanner, I should like to ask you, how do you fulfill integration within the space of the European Union? And what kind of advice could you give us with regard to our integration? The floor is yours, Mr. Tanner.
One, two, three. Everything okay? Now it works. Thank you very much for invitation here to speak here and to give a short report about the situation in the European Union. Of course, I can't speak for the European Union. Of course, I can only give the views and make a little presentation about the views of one small competition authority. And you will see after my report that it's possible to make a lot of initiatives in international cooperation, and I want to give you a short outline. I hope it works. Which one? Doesn't work. This one. I want to give you a short outline. I want to talk about competition law and the global issues. I want to talk about the goals of cooperation, the ways of cooperation, and the challenges cooperation and networks, and I will give you 3 small examples for, I think, a very good cooperation in the international area, and I want to make a short outlook in this area. If we look at competition law and enforcement, we can say that there is that we find that it is a global issue. We have questions of competition law and enforcement. We see that they are not limited by borders. If we look at a lot of cases, for instance, the cargo cartel or Intel or McAfee mergers, we see that especially in times of financial crisis, economies are interconnected, and we as competition authority, we are facing a well-informed, internationally well-connected business and lawyer community, of course. There is, for this reason, also need for a cross-border cooperation and coordination between national competition authorities, and so it's necessary to look for common position to solve common problems that it lead to a mutual benefit. And I think cooperation leads to harmonization on the long term, and this is beneficial to the enforcers on the one hand and to business community on the other hand. And I think the speaker before, Minister, told it in a very good way and made a very good example for future cooperation. If we are looking at the goals of cooperation, we have to look that we should increase our efficiency for our investigative steps, that we should avoid duplicating our work, we should avoid contradicting remedies in different authorities, but I think it's very necessary to create a transparent legal environment, and it could also strengthen our independence. If you look at the European and European Union ways of cooperation, there are 2 parts. There is the formal cooperation and a lot of enforcement activities. I want to give you One example, it's the Regulation 1/2003, the European Union, which is the basis for the formal cooperation of enforcement activities on the one hand, on the other hand for information exchange and in the cooperation for enforcement. But I think also very important is the informal cooperation, the exchange of non-confidential information in the form of bilateral update on recent developments, as I did it yesterday with my Russian colleagues. Thank you once more. Thank you very much. There are some methods to do and to strengthen this informal cooperation. On the one hand, there are memorandums of understanding, as the Austrian Federal Competition Authority has written it and signed it with FAS or with the Swiss authority or with the Serbian authority. There are a lot of possibilities for technical assistance, as Austria at the moment has a twinning project with Moldova, with study visits and workshops. And a third very important part are bilateral meetings, are some conferences or round tables. If you look at the possible stages of cooperation, we can see the pre-investigatory stage to get leads and to inform on the start of investigation, and the investigatory stage to get evidence, to coordinate steps, to share ideas on assessment, to share information on markets, and to inform on remedies, of course. There is in the European area one example of a formal cooperation including exchange of confidential information. It's the European Competition Network. I've listed here on one slide the experience in the work with this network. It allows a full information exchange. The first step, it allows enforcement cooperation, also for down rates. It allows the exchange of know-how. It facilitates informal contacts between case handlers, and it allows training for case handlers, joint training for case handlers. But there is also some scope for the future in this European competition network. There will be included mergers, and it's also the idea to avoid the duplication of work and to reduce the burden for some smaller competition authorities. And there will be a further harmonization of fines, procedural aspects, and investigative steps and tools. I want to give you now 3 short examples for a regional, I think very fruitful, informal regional cooperation. First example, there is a working group on oil prices organized by FAS and by the Austrian Competition Authority. I've listed here, the working group investigates issues on pricing at oil product markets. The members of these working groups are the the competition authorities of the Russian Federation, of Bulgaria, of Austria, of Kazakhstan, of Latvia, of Portugal, and Romania and Germany. So you see here, on the one hand, some competition authorities which are members of the European Union, and some competition authorities from the wider European area. And what's the idea of this working group? To discuss the existing approaches on monitoring and analysis in the fuel market and the fuel sector. There is the exchange of experience and approaches to the application of national competition law in the market of oil and oil products. There is a discussion in the exchange of information on the national cases, And one further idea is that a database should be created on cases on violating anti-monopoly legislation. The working group has started its work at the end of January in Moscow, and the next meeting will be in June this year in Vienna. First example. Second example, for an informal regional network, it's called the Machfeld Competition Forum. Members are small competition authorities in the European area, also Switzerland, Croatia, Bulgaria, Croatia, Romania, but also the DG competition. And the idea is to strengthen regional cooperation and coordination and the exchange of, once more, the exchange of information in the form of best practices. And there are already a lot of common positions has been defined, and a database with a merger information exchange platform has been established already. Second example. Third example, it's an informal network we built up together with the European Commission, with OECD and UNCTAD. We call it the Mediterranean Roundtable, and the following countries are participating in this roundtable. It's Algeria, Egypt, Jordan, Lebanon, Morocco, Palestine, Syria, and Tunisia. Because when we look at these countries, they build up new competition authorities at the moment, and so it's necessary to find and to provide a platform for information exchange to help each other in building up good and independent competition authorities. And a roundtable in Vienna in December last year discussed the next steps, which will be the following. One of the results was that we need some sort of platform for communication to foster the cooperation, but, and I think it's very important, as Chairman Ademiev also mentioned, the civil society should also be included, and the initiative will be, and it's building up at the moment, the Mediterranean Competition Council. It will be a flexible and long-term cooperation framework for and within the Mediterranean civil society, and it's open to all, including to international institutions. These were, I think, 3 short examples for informal, successful cooperation. I've listed up for you also other examples of regional cooperation. Begins with ISAP and the International Competition Network, the European Competition Authorities, OECD, UNCTAD, BRICS, the ICC, the Nordic Competition Authorities, and the Central European Competition Initiatives. If we look at the experience with competition cooperation in the international area, there are some challenges for cooperation and for these networks. There is overcome concerning the confidentiality issues with administrative burdens of notifications and information exchange. Networks are often criticized because of a lack of transparency, but I think if the business community is well informed, it's okay when the competition authorities are also well informed and inform them each other. We have different legal cultures, we have to look at it, and sometimes language could be a problem. Let me come to the end and give a short outlook and make a conclusion in 5 points. I think competition enforcement is becoming more international as business operates worldwide. And competition and cooperation should not end at the national or European borders, but is gaining a more and more international dimension. I think harmonization is good for enforcers and the business community, and I think we have to produce a win-win situation. And I think international cooperation forms an important part of competition advocacy, and I think this is a very important point. Cooperation needs a lot of preparation and a day-to-day effort to make it work. So I once more appreciate very much our bilateral cooperation with FAS, and I want to thank you once more for invitation to give a short presentation here. Thank you, Sergei.
Спасибо большое.
Thank you very much. Of course, it's really important here what Mr. Tanner said about the development of integration, which is another evidence that there's no getting back anymore. Any longer. We need to unify or harmonize as much as we can to promote and conduct unified antitrust policy. If you go together, you can win. Otherwise, you will lose. Let me share one point with you now. Possibly any country could accept a perfect antitrust legislation. Maybe sooner or later there is such a piece of law in place, but unless we have proper enforcement, any law, even a perfect law, would not be of much help. A great role in the conducting of the antitrust policy is played by the judiciary, which somehow or other will interpret the provisions of the antitrust law and makes it happen. Let me give the floor now to Oksana Yurievna Gvozdilina, who represents the Supreme Arbitration Court at this conference. And I'd like to ask her first, what is the interpretation of the antitrust legislation by courts, and what problems do you envisage there today? Oksana Yurievna, you have the floor. Thank you. I'm happy to welcome everybody here. Many familiar faces in the room. And of course, it happens that we meet each other at conferences. Yesterday at the plenary, unfair competition was a phrase that was mentioned more than once. Yesterday set the tone for this roundtable discussion today. And of course, unfair competition is perhaps one of the most one of those violations in the antitrust area that is of great interest for the anti-monopoly bodies, and there are many cases considered by courts with diverse outcomes. According to Igor Yurievich, only now unfair competition brings about success. I don't think so, for a simple reason that if we remember the classical literature, just remember O. Henry's short stories. All forms of unfair competition are described there. You remember short stories by O. Henry with, you remember the flooding of the dam and buying small shops in a town, and then people, men were willing to drink something, and there was only one pub left, or one bar left, and the prices skyrocketed. So if you just read classical books, you'll find many, many examples of unfair competition since days of yore, or the Golden Calf, the Russian classics. Unfair competition, maybe from classical literature you can derive many principles that would be very helpful for us. Very recently, by the way, I found an interesting document, the instructions of the Ministry of Justice of the early Soviet times. It was the anti-monopoly rules of the revolutionary times. The Revolutionary Tribunal was supposed to consider cases against people who stop or reduce the output of the staples without any need, or who conceal or destroy the staples in order to produce a shortage thereof in the market. So, and if we look at the legacy legislation, we will also see a lot of legal norms that date from the days of yore, and I've got a feeling that sometimes you think that practice is what drives legislation, and then the courts decide. And as a result of certain cases lost by the antitrust bodies, you would soon see an amendment to the law. It's good that the anti-monopoly bodies respond so fast to promote the Russian legislation, and at other times it seems that the legislation drives the practice, because even before the practice is there about a certain article, finally you have a clear interpretation by courts, and then bang, you have a new piece of law. This is the status of the Russian antitrust legislation. Just this past January, well, I saw in the agenda that the third anti-monopoly package would be explained here at this forum. But still, since January, we've seen significant changes, amendments to the Competition Act. The courts are just getting used to it. Those are quite global changes, and there is gossip that a fourth package is being drafted. I don't know what to expect there. It's very important for us to talk to our international colleagues, because they have done a lot. The interpreter apologizes for poor connection, because the sound quality is very low at the moment. I can't hear what the speaker is saying. Soon there will be an antitrust conference with judges coming from 6 countries, and it will be very interesting to learn about the court practice. Unfortunately, I have seen no colleagues of mine at this conference, at this forum so far. This way I started with unfair competition. Now the Presidium of the Supreme Arbitration Court recently accepted a case where the Presidium needs to decide if you...
Ничего не слышно. Мы ничего не слышим. Бесполезно.
To the extent the interpreter can hear the speaker, it is about establishing the minimum or low price, and if close to dumping, and if it can be considered an abuse, especially if done by a dominant party. The Presidium will look at that case shortly. The Presidium has considered other cases recently. You remember the Peterochka retailer. It was a case of unfair competition vis-à-vis the civil code of the Russian Federation. For our international counterparts, let me explain that Peterochka is a big Russian retailer that you can find in almost every big city in Russia, and the trademark owner under the commercial concession contract ceded the right of using that trademark in one city, the city of Kazan. And because the rights owner had the right of doing that under the license, but then after holding the license, the rights owner decided to buy that right and to enter the market itself. And the courts need to decide whether the anti-monopoly body was right, because as a result, the rights owner entered the market in the city of Kazan, who relied on the commercial contract that prevented others from participating. And that was the Presidium considered that case and said that while the civil code provides for certain restrictions for these kind of contracts that involve intellectual property rights, and unless the contract itself stipulates a prohibition for the rights owner to use the trademark, then unfair competition is not to be identified. Having said this, the Presidium of the Supreme Arbitration Court had a dissenting opinion of one judge who said that effectively that if the antitrust body had collected a different base of evidence, unfair competition might have been recognized. I know there are such examples in the English law and Australia, or rather practice in England, Australia, and the US. At least I heard it from my colleagues. For instance, if you have a retailer chain being built, and the rights owner can build his own facility right across the street bearing the same sign, and then the retailer would be losing the shoppers because people do not understand those are different entities. After my mentioning the unfair competition, let me talk about abuse in different markets. The Presidium has considered about 10 cases over the last 18 months regarding Article 10 on the abuse of dominant position article of the law. Currently, the Presidium has accepted 2 more cases. At some point in time, the Presidium formed several positions on the abuses. There is an acute, relevant issue for our practice about related or unrelated markets, but still where unrelated markets that maybe even if unrelated are operated by the same dominant player. If a company is dominant in one market while the abuse and abusive entry markets are created by the same player in the related or unrelated markets. There was a letter sent to the Presidium one of those days, and the Presidium has to decide about unrelated markets. For instance, Russian railways, the dominant player in the railway transportation market, and when selling railway tickets, they were also selling insurance policies through their Jasov, it's their insurance arm. I, as the consumer, have seen that more than once, and the courts, having considered that case, the courts ruled that since Russian Railways is a dominant player and is unrelated to the insurance market at all, while the ticket offices in Russia are employed by Russian Railways while serving as agents for the insurance company, but they use the infrastructure of Russian Railways, they were selling those insurance policies. The anti-monopoly body collected a lot of evidence, and the personnel who worked there, they admitted that indeed when selling railway tickets, they used tied sale arrangement without explaining you could buy an insurance policy from somebody else, and that was the way for the courts to interpret that. Now the case has come up to the Presidium, and it is up to the Presidium to say, yes, the Russian Railways is dominant in the rail market. By the way, it is now being considered by the Agency for Passenger Transportation. Russian Railways is a natural monopoly, duly registered as such. And therefore, the Presidium will have to consider if a company is a dominant player in a certain market.
If the company is dominating in the transportation market, what can be done that the railway does not have a leading position in the insurance market? So we raise these issues, and I have to add that insurance policy, insurance is arbitrary, it's voluntary, it's the other side of the medal, and the consumer, the client, may not wish to buy this, does not want to buy from this insurance company. He or she can go to another insurance company, and this is a classical proof of tying. Yes, the railway, the Russian railway, is dominating in the railway market, but using its position, they have the possibility to impose their demands and their rules on another subject. Consequently, Нет. Нет. Сейчас вообще не слышно. Yes, 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 yes. Now I can hear that, well, you can hear me. So it was like a promotion, what will be discussed by our presidium. And for example, our foreign colleagues, they probably do not understand what I'm talking. Our arbitration system is considering all the matters, all the cases related to the arbitration. And it is very rare that the arbitration cases go to the superior instances, and the superior commercial court or arbitration court, they have to follow the correct enforcement of the judicial procedure, but the primary task of the court is to bring justice to both parties, and so that they could solve their matters before the court case, because the number of cases is increasing geometrically. Antitrust cases, they are increasing in the geometrical proportion, and the court just doesn't have the practical force to solve all these matters. So I should like to support the topic which were raised by previous speakers about the harmonization, about the code of the customs union. Of course, the competition has a very distinctive character, a very distinctive manner. With the establishment of the customs union, we need to work out unique norms and regulations. And I would have a suggestion that probably we have to unite and combine competition, taxes, and customs, because all these parameters, they belong to the economic sphere. And the procedure, the course of all the checkups is similar to each other. And it is the matter of fixing prices in order to avoid problems and issues in these matters. I think that probably it would be worth to identify all these spheres closer to the financial sphere and to come to a unique conclusion. And then we will be able to avoid problems with the courts, because in the Russian legislation there is a visible conflict. Of course, I want to ask the same question. I want to ask my foreign colleagues what is happening in their countries, what is the proportion between the taxation regulation, customs regulation, and competition regulations. Do we have any issues? And what I should like to say, that we've tackled, Mr. Theodor Tanner tackled a very interesting issue, And it is interesting how we will regulate all these matters. And I should like to hear whether it is a possibility for the courts to consider these cases, how the courts of certain countries and the unique European court, do they consider cases relevant to the antitrust, and how do they use legislation, because we will still have to do it, and it is difficult to imagine how it will look like. And last but not the least, I want to tell you not to waste your time. I should like to remind you because, well, I think that some of my colleagues, they think about different things. And there is a joke. If you ask the audience of businessmen, which sound is the most pleasant for them, and they will say that this is the sound of new banknotes, or it is the drop of the competitor. And I think that all the audience, they are waiting for a coffee break, and you are a little bit fatigued. And thank you very much for your attention. If you have any questions, do not hesitate, and I will be pleased to answer them. Thank you very much, Oksana Yurievna. We will have a coffee break in a couple of minutes. It will last 15 minutes. In 15 minutes' time, please come back to this room. Then we will have 3 more speakers, and then we have a roundtable discussion and ask questions, have a dispute, probably draw some conclusions. So, dear ladies and gentlemen, we will have a 15 minutes break, and after 15 minutes we will resume our
Уважаемые дамы и господа,
ladies and gentlemen, we resume our work, and as I promised to you, we will finalize the speakers' presentations, and then we will be able to organize a roundtable discussion relevant to the issues which are specified in our program. The coffee break proved that the practical issues, that we have lots of common issues for the foreign participants, for the speakers. And now I should like to give the floor to Michael Grenfell, to the partner of the company Norton Rose. He worked in a Ministry of Trade and Industry of the United Kingdom. He was a legal consultant of the Supreme Courts of England and Wales. He has a pocket of experience in the field of the antitrust policy, and it would be interesting to listen to his opinion.
Thank you very much. First of all, can I say what a great pleasure it is to be with such distinguished colleagues, and also what a great privilege and honor to be in this beautiful city. Yesterday, when we had glorious sunshine, I also had the feeling that after the terrible weather we have been enjoying in London, or enduring in London, it was a great privilege to enjoy your glorious weather, but looking outside, I'm made to feel very much at home now. I'm going to talk today about the way, or the perspective, of the European Union and the British competition law and policy system on coping with the globalized world and the globalized economy. And I'm going to say, first of all, that really in the last few years, faced with the globalized world in both Britain and the European Union, really there have been 3 considerations that have been on the mind of competition policymakers. The first is, and the first one is one which I think is common to competition authorities and courts and legislators worldwide, which is the protection of consumers and the promotion of efficiency through competition law. But secondly, there has been a consideration that one should not, in a globalized world, overburden business with regulation, or perhaps to be more precise, not impose unnecessary regulatory burdens. They should be proportionate to what is necessary. And lastly, in a world where capital moves very freely around the world, a concern not to have a regulatory regime that is hostile to and deters foreign investment in the territory. Now, I'm going to talk about 4 ways in which those considerations have played out in Europe and in Britain. First of all, and that's very much linked with the protection of consumers and the promotion of efficiency through competition, the punishing of anti-competitive behavior. So I'll first talk about the punishing of anti-competitive behavior. Second, how competition authorities best deploy their limited resources to ensure that competition law is effectively enforced. Thirdly, and this has been very much a preoccupation of the UK and European authorities, the balance between legal and economic factors in the enforcement of competition law. And then, fourthly and lastly, I will say something about how the authorities seek best to ensure that the regulatory regime does not deter foreign investment, foreign investors. And I hope that some of the themes that I will talk about are not only of interest, of course, to European lawyers and policymakers, but also have a relevance to competition law enforcers, policymakers, and practitioners in other parts of the world, including here in Russia. So, to move to the first of those 4 ways in which these considerations play out, the punishment of anti-competitive conduct. And certainly the last few years have seen a real determination on the part of competition authorities at European level, at national level, including in Britain, to make the punishment for anti-competitive practice that much stronger than it has ever been, so as to weed out anti-competitive practices for the protection of consumers and the promotion of efficiency. By way of an example, fines that are imposed on companies have risen by enormous amounts. If I can give an example that's on the screen, in the European Union, since the early 1960s, it has been possible to impose fines on companies that breach the competition rules of up to 10% of the worldwide turnover, the worldwide revenues of the company group, of the whole corporate group. But in practical terms, the actual level of those fines has gone up massively in recent years. And that can be illustrated by this, that the 4 highest single fines in the half century since, slightly more than half a century, since the European Union has had the power to impose fines for anti-competitive practices, in that half century, the 4 highest fines have all been in the last 4 years. And before 2009, there had never been a fine of as much as €500,000. The fine on Microsoft came close, but wasn't quite half a billion, sorry, 500 million. There had never been before 2009 a fine of as much as 500 million euros. Since 2009, there have been 4 fines above 500 million euros, one of which, a fine on Intel for abusing its dominant position, was over 1 billion euros. I think that gives a sense of the hugely increased emphasis that the competition authorities in the European Union have placed on punishing anti-competitive practices. And if you look at the figures for the United Kingdom, a similar pattern shows that the very highest fines have been in the most recent years. And that does not just reflect inflation, it's even taking account of that. It is a massive increase in fines. In the United Kingdom, there are also other tools that can be and have been used to punish anti-competitive practices. 10 years ago, a law was introduced to make it possible for the authorities to impose criminal penalties on individuals in companies, individual people in companies who are directly involved in the most serious anti-competitive cartel agreements, price fixing, carving up markets, and so on. Now, in the 10 years or so since that, and the penalties can be very severe for an individual. They can be significant fines on the individual, and imprisonment of up to 5 years in prison. But in the 10 years since the UK authorities have had that power, it has hardly been used, and it has proved not to be very effective. But as a measure of the seriousness with which the British authorities take this power, they are now proposing to change the law to make it easier to apply this criminal process. In addition, and I know you said that this is in Russia as well, there is the power in the United Kingdom to disqualify directors of companies that have breached either British or European prohibitions on anti-competitive practices, to disqualify them from being director of any British company for a period of up to 15 years. And then lastly, it has been made easier for people to bring private litigation claims in the courts and to obtain damages, and there are proposals afoot to make it even easier, and there are proposals both at national and at European level to do that. And of course, the liability to damages is a very, very serious fear and deterrent for companies, although of course it also raises a question whether that is a proper mechanism for public enforcement and public priorities, because it clearly is a method of private compensation, but in terms of priorities and in terms of objective, of course it isn't the same as the protection of the public interest in terms of consumers and efficiency. So, as you can see in that first respect, there has been a huge emphasis on protecting consumers, promoting efficiency through vastly increased punishments for anti-competitive practices. The second way it has played out, again with a view to stronger enforcement of competition law to protect consumers and promote efficiency, has been through making the most of the competition authorities' resources. Now, I am sure my colleagues here on this panel who run competition authorities will agree that there are never enough resources and that there is always too much of a limit. And certainly in Western Europe, as people will know, all the countries are cutting down on state spending, and so there are even fewer resources available to competition authorities, or it's more constrained. Competition authorities and the law has responded to that by seeking to target more efficiently the limited resources they have. Partly, they have introduced self-assessment by companies of anti-competitive behavior rather than a notification system, so that it used to be the case until 2004 that if you were concerned that your agreement might be anti-competitive, you could notify either the European Commission in Brussels or national competition authorities in the member countries of the European Union, notify them, and the competition authorities would spend resources on checking whether your agreement was problematic or not. Now, the effect of that was competition authorities devoted a lot of resources to agreements which were notified, and agreements which are notified by businesses are by and large not the most seriously anti-competitive agreements. The most seriously anti-competitive agreements are the ones which businesses hide from the competition authorities. And so from 2004, it was no longer possible to notify the authorities of agreements to check whether they were okay. It is for the companies to assess themselves and with their legal advisors whether their agreement is in breach or not. And of course, if it is in serious breach, then they run the risk that a competition authority will investigate it or that someone will take litigation proceedings in the court. But there is no possibility to notify. And in Britain, in merger control, similarly, it is for businesses to self-assess whether their merger is problematic, and they only notify, they voluntarily notify if they think it is problematic. At European level, there is a compulsory notification system for mergers, but in Britain there isn't. Britain has a self-assessment voluntary system. The British government in the last year has been reviewing the competition law and procedures for Britain, and one of the things it considered was whether to move to a compulsory notification system for merger control, and just last month it announced that it had decided not to do so. And again, that self-assessment system means that the authorities can concentrate their limited resources on the most seriously anti-competitive mergers. In addition, both the national authorities and the European Commission enforcing EU competition law has developed a system of prioritizing complaints so that when someone complains about an anti-competitive practice, it won't automatically investigate it. It will see whether, in terms of the public interest and consumer protection, it is a high priority issue or not, and it will devote resources to those complaints which are high priority. And again, of course, a way of freeing up resources is to rely on private litigation, to rely, instead of dealing with complaints through the competition authorities, to say, well, you can go to the courts and have private litigation. But again, the problem with that is that the prioritization with private litigation is arbitrary, and it depends on really how much money is at the disposal of the person making the complaint. So it is not a public interest prioritization. It is to some extent arbitrary. So those are the ways in which with their limited resources, people the competition authorities attempt to maximize the use of their limited resources for the protection of consumers and the promotion of efficiency. The third issue, which again has very much preoccupied authorities, the European Union, Britain, authorities throughout Europe and indeed in the United States, is how much legal input and how much economic input should there be in the assessment of anti-competitive practices. And there are arguments for favouring one over the other both ways. Certainly in the last few years, increased emphasis has been given to economic analysis for very, very good reasons. An economic analysis rather than a formal legal analysis means that the assessment is more more real, more precisely calibrated. And that, again, means that you catch what really matters, which is important for proper competition enforcement, protection of consumers, promotion of efficiency. It's also important for businesses because it means that only those things that are really anti-competitive practices are subject to regulatory enforcement. Those things that are not so serious are not. But the difficulty with giving too much weight to economic analysis is that although it is more precisely calibrated, it is less predictable than a more law-based approach. There is less precedent, it is less easy to predict what will be done from the written laws and the written decisions. And of course, predictability and certainty is very, very important for business, and businesses suffer when there is uncertainty and unpredictability. And it's also actually important for the promotion of efficiency, which is one of the goals of competition policy, in that if businesses are uncertain, there is what people call a chilling effect on economic activity. People are frightened to do things which may be perfectly okay, which may be perfectly lawful, because they fear, they are uncertain whether they will be punished for it or not. So a classic example of the way in which this has played out was that the European Commission spent a lot of time in the last few years working up a paper, which it now calls its enforcement guidelines, on how it will deal with abuses of a dominant position that aim to exclude competitors, exclusionary abuses of a dominant position. And in that paper, it moved very radically from an old formal legal approach to a very, very sophisticated economic approach, essentially saying that an exclusionary abuse of a dominant position is only problematic insofar as the competitors excluded are as efficient as the company that is doing the abuse. So if it excludes inefficient companies, that's not so bad. So that's the principle, and in economic terms it makes a lot of sense. But applying it in practice as a law meant that a huge degree of sophisticated and complex economic analysis would have to be applied to every unilateral behavior or commercial decision by a dominant company, and that would be hugely problematic in terms of uncertainty and in terms of the burden of having to do the calculations and the analysis, and in terms of the chilling effect that I talked about earlier on. And in a way, that paper is a classic example of the difficulties with the economic analysis for all its virtues. And interestingly, just earlier this year, there has been a judgment by the European Union Court, the TOMRA judgment, on an abuse of a dominant position aimed at excluding competitors, which has moved back very much to the more formal legal approach, not ignoring the economic analysis, but not giving it as much weight as that European Commission guideline did. And then the last of the issues I wanted to talk about was making sure that competition policy, for all its virtues, is not such that it makes the country unattractive to foreign investment. And that's an issue not just for competition policy makers, but of course for governments in their entirety which want their countries to be prosperous. And I would suggest that in Britain and in Europe we have learned over many years that the ways to do that are to ensure that your competition authorities are robustly independent and not subject to too much political interference. And certainly in the last few years in Britain, they have removed political interference in the competition law process, and the reason for that is similar to what we've been discussing earlier. With less political interference, it's more predictable, it's more certain, it's less arbitrary, and those are things that foreign companies wanting to invest in your country are very preoccupied with. Making sure that policies are reasonably consistent and predictable. Making sure that decisions are reasonably quick, particularly in merger control. And let me just say something about that. As a private sector lawyer who advises companies very often involved in mergers and acquisitions, it is on the bigger mergers and acquisitions, it is the most senior people in the company who are involved and concerned with the outcome. And if a country has a very slow system, that is a huge issue for the progress of that merger and acquisition, and may even make the difference between it succeeding and failing. And the most senior people in the company notice that and remember it about the company, about the country concerned, and it affects their attitude to the country concerned, not just as regards competition, but as regards their feeling about the whole country. The same is true about the jurisdictional thresholds for merger control. They really, I know there is a balance to be struck, because competition authorities want to catch those foreign mergers and acquisitions that may have a real effect on consumers in their country, and that is perfectly legitimate. But in doing so, they need to be proportionate and reasonable and not allow the net to spread too widely, which means there needs to be some degree in the thresholds of a reasonably high degree of business activity by the parties in the country concerned. And many of you who have experience of this will know that Ukraine, for example, has had a ridiculously low Ukraine turnover threshold of, I think, just 1 million euros, so that merger transactions that really have no effect whatsoever on Ukraine need to be notified in Ukraine, causing expense, causing delay. And again, what I said a moment ago, the most senior people in big international companies notice that and remember it about the country, and it affects their attitude to the country. Now, I'm pleased to note that, I'm sorry that I singled out Ukraine, because Ukraine is aware of this and is just this year amending its law in that respect, but the general principle holds good. So, in all that I have said, in order to promote competition through protecting consumers, promoting efficiency, in order to not to over-regulate business and therefore to allow good economic activity, in order not to deter foreign investment, competition authorities and legislators making competition policy have to strike very, very difficult balances between enforcing just enough that bad practices are caught, but not so much that perfectly innocuous practices are hindered, and in a sensible balance between law and economics, and between catching those foreign transactions that matter, but not deterring foreign investment. And these are very difficult balances for competition policymakers and authorities to strike, but it's essential that they do strike them correctly, and I think there are lessons to be learned from experiences of competition jurisdictions all around the world. Thank you very much.
Спасибо большое, господин
Thank you very much, Mr. Granville. Indeed, the points you have raised are very relevant for any jurisdiction, including this country. This country is because a proper balance to be struck between the legislative regulation and the prohibitions and use will always have a very strong influence on the economic climate in the country, and it's very important to find a good balance here. Let me give the floor now to the respectable James Flynn, the Royal Councillor, very experienced in the practice of anti-monopoly regulation, also, among other things, as a practicing lawyer. He must have his own opinion about what we have been discussing. You have the floor.
That's better. Can everyone hear me now? And raise your hands if you can't. I'd like to add my thanks to those of other speakers for being invited to this most enjoyable as well as stimulating forum in this wonderful city. Could I add a particular word of thanks today for the interpreters who are doing a fantastic job, and without them we'd be having no dialogue at all. My perspective, as the chairman has said, is that of a practicing lawyer. In our system, we have two types of lawyers. It's complicated, won't go into it, but Michael, as a solicitor, has a predominantly advisory practice in a commercial law firm. I am predominantly an advocate, a sole practitioner, largely dealing with cases before courts of one sort or another, and I'll come on to what sort of cases. So far, my only personal interaction with the Federal Anti-Monopoly Service was quite a few years ago, and I think before the incumbency of Mr. Artemyev. I was asked to provide an opinion in relation to some measures taken by a regional office of the Monopoly Service in connection with distribution agreements. And I was asked to provide an opinion simply how would those agreements be treated under European law, and my opinion was that they would be regarded as utterly innocuous, whereas under Russian law they had been prescribed. And my opinion was then translated into Russian, taken before a notary, and had lots of green tape attached to it, and so became even more valid and strong. We were told that we didn't stand a chance until we got to a further level of appeal, I think, in Moscow, and I never heard the outcome. So that's my first experience. But consistently with that opinion, I wouldn't presume to say to you how how Russian competition law or the neighbouring countries or your association with Kazakhstan and so forth, how that should develop. What I can do is provide a bit of perspective on what might happen if you go down something approaching the European Union route, which is, of course, what we have, what I have as a practitioner in the United Kingdom. And I should say also I have worked at the European Court in the past, so I have some familiarity with it. And I think the first thing I would say from the institutional perspective is what you're likely to get, I'm afraid, is permanent revolution. There's always a search for better instruments, better techniques, better modes of enforcement, better modes of passing through economic policy onto the ground. And experience over the last, my last 25 years in practice, and actually if you take a historical view, really since the beginning of the previous century, is that the rules are simply always changing. Reference has already been made to the great reforms in the European Union which came into effect in 2004. They've already been spoken to, with the explanation of how the approach has turned from an essentially legalistic, form-based approach to agreements, for example, to one of much more economic assessment. I think it's also very important to realize that what that regulation also did for the first time was to allow national competition authorities, such as that in Austria or the United Kingdom, themselves to apply European Union law. Before that, that had been the monopoly, if I can put it that way, of the European Commission in Brussels, with the notification system that Michael particularly has mentioned. So what happened in 2004 was not only a new approach, as it were, on the substance, but also a new approach to enforcement, which we generally call decentralization. But nevertheless, this is decentralization to national competition authorities with their own national competition laws, which may differ quite considerably. It's not, and I think Mr. Tanner already mentioned that, it's not itself a harmonization measure. There is no requirement that member states of the European Union in their national competition law adopt the same approach or anything resembling it to that of the European Union. In practice, most of them do. So there is this sort of harmonization, sort of impetus, but it's not a legal requirement. And you do find within quite a variety within the national systems, including as to the institutions which apply competition law. And I think it's the case still in Austria, for example, that ultimately the decisions are taken by a court, by a special court, and not by an agency. And I believe that it's still the case in Ireland, for example, that as a constitutional matter, only courts can impose fines. So that's not open to the competition agency. But these differences gradually, it seems, get ironed out. An interesting facet is that this system is, to some extent, exportable. It's a model which has proved attractive elsewhere. So you will find that competition laws in, for example, Hong Kong and Singapore, which have very little to do with the European Union, in fact resemble that system quite considerably. I just say it is permanent revolution because, as Michael has already mentioned, there are quite significant changes to the system in the United Kingdom about to be adopted, both at the institutional level, with the merger of our two principal competition authorities, and also for, under consideration anyway, rules for enhancing and making easier private actions, private civil law actions for damages for those who consider themselves affected by breaches of competition law. So against that sort of background of a constantly shifting legislative enforcement framework, there are a few tendencies which I've really noted very, very strongly in my practice over the last couple of decades. The first has been touched on to some extent. It's internationalization. Whereas competition authorities used to live in a kind of little silo, applying their own laws, their own peculiar little merger control laws or strange rules, as very much so in the United Kingdom, to price fixing. They now talk, cooperate, share information, and know each other absolutely all over the world. And Mr. Tanner's very interesting examples of very specific cooperation on a regional basis really tell that story. And the International Competition Network is immense. That's the name of a body, I should say, not just a term that I'm using. The capital I, capital C, capital N International Competition Network has most competition agencies meeting regularly at pleasant locations around the world, such as recently in Rio de Janeiro, for a week, sharing best practices and telling each other what they're up to. And there are a large number of such agencies. In response to my colleague on my right, Madam the Judge, there is also in Europe an association of European competition law judges. And they meet and share practice and talk about what they're up to and how they deal in their courts with damages cases or administrative appeals against agency decisions and so forth. So this internationalization is a huge change, and it's only going to get more so in my view. One result of that is a slightly unexpected phenomenon, perhaps, is that Brussels, the headquarters of the European Commission, seems to have become the venue of choice for fighting out US disputes on supposedly dominant technology firms. I mean, years ago we had the IBM case, which played out in Brussels as well as in the US. But more recently, you've seen Microsoft, as Michael said, paying the highest fine in European Union history, and condemned for practices which had not been condemned in the United States, thanks to some crafty settlements procedure. And the Microsoft case is interesting because you had the entire American industry arguing their case in front of the European Court. You had Microsoft, Oracle, IBM, Novell, you name it. It was essentially an American show in Luxembourg. And that's going on now with Qualcomm, whose technology is at the basis of 3G mobile phone technology, with Google, Apple, and Intel has already been mentioned. Looking at it the other way, the long arm of the US extradition rules seems only to be getting tougher. So people who at one point were in what they would think of as a domestic or regional cartel suddenly find that actually they're in an international cartel, and the senior directors are wanted wanted for a trial in the United States, and are cut out of the settlement deals that their company makes. So we had an enormous case in the United Kingdom, an executive of a company called Morgan Crucible, who'd been found to have been price fixing all around the world, and he was said to have led it and to have led a cover-up, so that if they were ever investigated, all the evidence would be destroyed. And the US carved him out of the settlement deal and pressed for his extradition, which in the end happened, at least for the cover-up. So we can't just talk, even though say Michael and I are essentially EU and UK competition lawyers, we can't ignore what's happening in other jurisdictions with long arms. Now, I think this comes back. There was some talk yesterday in the plenary about good and bad competition or overreach of certain legal systems. I think these days that's largely been replaced by the sort of cooperation models that I've talked about, but there is, I think, still on the British statute books an Act of Parliament called the Protection of Trading Interests Act, the effect of which is to block what are seen as excessive US sanctions. The massive fines Michael has spoken of, the simply colossal fines that are now being imposed for anti-competitive conduct, and those are said by the theorists and some influential voices in the European Commission not to be nearly enough, because your ideal fine should be the gain that you expect from the practice inversely multiplied by the risk of being caught. And once you apply that formula to some of these cartels, then you're heading straight for immediate insolvency. And that's why there's been such a pressure in various jurisdictions, and the UK, as it were, leading the charge for criminalisation, because the theory is, unless you can catch the directors and disincentivize them, the company will never pay. The fines will simply never be sufficient. These massive fines and the possibility of criminal penalties lead to another issue, and that's perhaps where I'll stop. What is happening and becoming ever more important in our practice is the role of fundamental rights in the case law, and fundamental rights deriving not only under the European Union rules from common traditions of the member state, but also from the separate instrument of the European Convention on Human Rights under the Council of Europe based in Strasbourg. Even now, before the European Union becomes a member of the Convention, which it is committed to do when the modalities can be worked out, the importance of fundamental rights legislation is becoming ever more pronounced. Originally, it went to matters such as double jeopardy, so being prosecuted for the same crime in more than one jurisdiction, to the level of fines, or to the way that investigations are conducted, and so forth. But the next step, and this is coming, really goes to system design itself, because the question based on the right under Article 6 of the Convention to a fair trial will now affect how the agencies conduct their investigations, but also the extent of review by an independent court. And that, I think it is important in these times of ever stronger regulatory bodies, competition agencies, for which there is no competition. There was the old joke was in the cartoon in the waiting room of our Mergers and Monopolies Commission. As you waited there to go in for your investigation, there was a cartoon from the newspapers, and one businessman was asking another, why is there only one Monopolies Commission? There can only be one Monopolies Commission. They have extremely strong powers, and this has to be balanced by thorough and effective scrutiny in the courts. And that is being required by the jurisprudence of the European Court of Human Rights in Strasbourg. And again, to answer one of your questions, will affect the way appeals are conducted in the European courts, because the level of scrutiny of these decisions will have to be ever more thorough, and the courts will have to reach their own view on the appropriateness of the conclusion reached, and not just by the process by which it is being reached, if they are to satisfy the exacting standards of the fair trial rights under the Convention. So I think if you add all that up, if you add up permanent institutional revolution, you factor in huge fines, big damages cases really across the world, strong regulators with the ability through the economic approach to really reach conclusions which courts may find difficult but have to review. I think you will see that you've got a very exciting 20 years in front of you. Thank you very much.
Thank you very much, Mr. Flynn. It is true that the issues which are relevant to the enforcement of the antitrust legislation, they should be based on its stability, and the drastic changes in our legislation, they must have like an interim efficiency. We must stop, and we have to learn how to correctly use it. So, well, let's hope that if we have the fourth anti-monopoly package, it will appear only in 20 years' time, and it will only improve the stability of our legal system. And now I want to give the floor to Mr. Evgeny Voyevodin, with the conclusive report. And Mr. Voyevodin is the chairman of the General Council of Non-Commercial Partnership. It is not a conclusive report, not a conclusive presentation, but this is a report on the topic which was tackled by my UK colleagues. Partially, they talked about the The topic of our event is globalization, and within the conditions of globalizations, the extraterritoriality. The issue, extraterritoriality, is when one country, one state, uses its own laws and policy with regard to the actions fulfilled beyond its territory, and sometimes there are some problems arise with regards to the use of other norms. This issue of extraterritoriality will mean more and more, because this issue will provide the solution of this problem, will provide the defense of the competitors. And up to now, up to recently, we were mainly talking about this issue only in this case, in the case when we were talking about the process of control of the economic concentration. For example, when the deals are concluded, the consultants, they have to monitor and to see how this or that deal influences on the market. In my case, it is the Russian market, and whether it requires the agreement with antitrust bodies. In the old law until 2006, these norms relevant to this issue, they were contained in this article, and as the antitrust right in Russia celebrates its more than 20 years. It's not a long history, but it's a bright and efficient history. And at present, we have a very efficient tool of regulating this issue. If we talk what we have in the new legislation with regard to the latest changes, I mean that the lawmaker moved forward and added a few more norms which specify the institution of the law regulation. But in our case, we have to talk about the monitoring of the process of economic concentration. We have norms, any norm relevant to the extraterritoriality. If we look into it, deeper into it, it is based on different doctrines. If we do not talk about USA and European Council, then these doctrines, they could be different, but in several countries they merge. But my main topic is not to go deeper to this problem, but rather to demonstrate what we have in Russian Federation, what experience we have gained, and how we could develop it further. If you paid attention, I would say that the earliest doctrine possible was fixed in 1945 in USA in a case against Elkov. And if we consider the old law about the competition, then we may draw the conclusion that our provision about the extraterritoriality is based on the doctrine of influence. What does it mean? It means that the norms contained in the competition law will be used to the relations which appear beyond the territory of the Russian Federation towards the deals or which may influence the processes in the Russian, which happen in the Russian Federation. This is the general law, the general position. And when we were using this law, we were faced with a question. We were quite narrow in our vision. We couldn't understand how this position, how this provision could be used in the field of deals, of signing the deals. But now it embraces all the norms, use of all the norms of legislation with regard to the acts and actions which happen beyond the territory of the Russian Federation, but which may focus, which may influence on the competition in our Russian markets. Since this control over the economic concentration is repeatable and practitioners, practical lawyers in this field, in the competition area, they face these issues, then these suggestions which were made with the goal to amend the law and which were advanced by the Antitrust Service, they concern the provisions. And we have now the Article 26.1, which describes all the requirements of the economic concentration, that they can be used for the foreign countries if they exceed the threshold of 1 million rubles when they supply different commodities to the Russian market. My colleague Michael Grenfell, he reminded us about the positive experience of Ukraine when they had a threshold of 1 million euros, because it positively influences on the foreign investors. We also have this practice in Russia. Our threshold is higher, but I think it has the reasons to be more high. This Article 26.1 contains general provisions which are relevant for the deals with regard to the foreign companies, and the norms which are described in the Article 28.9. They tell us about the deals which require agreements. It is worth to mention that the deals which are described in this law, and in particular in the Article 26.1, they are concluded not towards the Russian economic assets, shares, and rights of these communities, but with regard to the foreign persons. This is the new thing, and I would say that the lawmaker deviated from the doctrine of influence, and he suggested a more formal provision in the law with the clear criteria. There are thresholds of the economic supply depending on the amount on supply, and any deal with regard to the foreign investor, foreign participant, requires agreement with the antitrust bodies. Despite the fact that this law exists only from the end of the last year, the antitrust body, they have worked out certain requirements. And in my presentation, I should like to clarify once again, to sum up and then to divide what I'm talking about. We have this problem which relates to all the norms of law, and we cannot talk about only use of these norms with regard to the economic concentration. We have to remember about the international cartels, and what is most significant, what presents most significant problem with regard to the antitrust conduct. And I think that cooperation, the experience of which which we gain from our foreign partners, from Kazakhstan, or this cooperation will help to solve the problem.
At the same time, the norms of extraterritoriality, I think, should be present in the national legislation to be actively used. The last thing I'd like to share is that if we look at newly made amendments to the law, it might make sense to continue their further improvement for better understanding. Michael in his talk had a very good phrase that indeed for businesses, for consultants, clear understanding of the law was required. And the fact that we have new norms on economic concentration, that is really good and important. And thus we achieve the goal of making it all understandable and clear for businesses and advisors about what they should inform the anti-monopoly bodies of. But then I think we should go further. What regards not the formal notions, but enforcement, so that enforcement is made more detailed and more clear. Having said this, general principles and norms of extraterritoriality should remain there, and anything outside of the Russian Federation that could have an impact on the competitive situation in Russia should be analyzed by the antitrust body on a case-by-case basis. Thank you very much. Thank you, Evgeny. Indeed, the extraterritoriality problem in antitrust regulation has been quite relevant. It is close to the problem of competition of jurisdictions, and the problems you raise are very important. Well, we have all panelists spoken, and our first speaker, Mr. Artemyev, spoke before he heard the following points by other panelists. So I'd like to ask Igor Yurievich before the Q&A session, maybe he has some comments on what was said by other panelists. And this could be the grounds for our further discussion and summary. Thank you. First of all, I'd like to thank all our guests for coming to St. Petersburg with very interesting presentations. There are several things I'd like to briefly touch upon. Firstly, much was said about the chance of over-regulation, including through anti-monopoly legislation. In this regard, I tend to always agree and discuss with the professional community and the businesses where there are cases of over-regulation. Because if there is a novelty, legal novelty with excessive pressure on businesses ensuing from that, yes, there are such cases, and we will do our best to try to eliminate that. For comparison, according to Mr. Freeman, every year they have about 20 large investigations that end up with their turnover fines. Last year, we exacted more than 3,000 turnover fines. So as you compare, it seems that we have an over-regulation and excessive burden on businesses. But you need to take into account an important thing. We had to change mentality of business managers and owners, and we've only been doing that for 5 years, not 20, not 50, just 5 years. So we thought a massive attack was required against bad practice. And we think that this kind of attack should be maintained for a few years more, so that there is a real click to the better in the minds of managers, so that they do understand it. But already now we're talking that the number of cases should be diminished heavily to relieve the judiciary, and hence we have preventive measures without imposing turnover fines. This is about over-regulation. Next, about international cooperation and international crimes. International cartels are criminal organizations, and most countries have criminalized that conduct, so we don't need to sign any supplementary documents between the countries or in Europe or between Americans and ourselves in order to pursue that, because there is the International Convention on Mutual Legal Aid. EO, for instance, we can rely on that. And if we refer to the police here to produce an international warrant for investigation, Interpol will do that. What does it matter if it is a simple criminal or an international cartel? And the Eurasian Commission and national bodies, if they seriously think about doing international cooperation to fight international cartels with Russia's involvement, we don't need any new international treaties or conventions to draft and sign. Already now we have legal instruments and documents to rely upon, and we need to seriously think about that. Two very particular things. We're going to reduce the number of cases for turnover fines. We will do our best to develop the private litigation arrangements so that especially government officials who hinder competition were counted by Russian citizens, Russian associations, professional associations, you name it. We want that, for instance, a builders association could freely go to court against an act by the Ministry of Construction without any involvement of the public prosecutor's office of the anti-monopoly body. I'm dreaming of seeing this happen. We are discussing this now very actively. And finally, one last thing, that's the relationship between the IPR and the antitrust legislation. What we have seen in Europe over the recent years, makes questionable this foundation of the protection of IPR, where competition is conscientiously restricted, or where a large damage is done to the public interest, where there is some parasitic entity or a parasitic patent, whereas the society badly needs some innovative idea to be implemented. And recent cases considered in Europe are of great interest. I feel deep respect to the achievements in various countries, including Russia, in the protection of IPR, but we need to understand as well that some qualifications or reservations are required where the anti-monopoly legislation should have a dominance, should overrule over other pieces of law. We will work on that for sure, because it is what the society needs. There will be package 4 and package 7 and package 8, because this is what the society wants. This has been a meeting that is really interesting, because we get first-hand information on how it really is. It's much better than reading 100 books, because you hear things from people who really do this, who really create this. Thank you very much for all your ideas and presentations. Thank you. Thank you, Igor Yurievich. We have a unique opportunity to ask questions from the panelists. Go ahead, please. But please use the microphone as you speak. Thank you. Good morning. I have a question to Igor Yurievich and to you, Sergei Anatolyevich. Indeed, according to Igor Yurievich, a total attack on businesses was justifiable. I agree with that. At the same time, the antitrust body has plenty of authorities or powers. On the other hand, there are cases where the antitrust bodies go beyond their terms of reference. In particular, in late February this year, the Presidium of the Supreme Arbitration Court decided the dispute between the anti-monopoly body and the energy distributorships. The point was about the regulated prices and tariffs, and the regulator who sets the tariffs in a controversial situation, in a contentious situation, commented that the distributor was absolutely correct in applying the tariffs. That's the prices. However, the anti-monopoly body disagreed. and brought the energy distributor to liability. And it was the Presidium of the Supreme Arbitration Court who said that in a situation where the regulator itself indicated that the prices were applied correctly, the anti-monopoly body didn't have an authority for making other people liable. Hence a question. Oksana Yurovna was talking about that. As an anti-monopoly body loses a case in court, they would quickly respond by making amendments to the legislation. And my question relates to this. What about this situation? Are you going to expand your authority by drafting amendments to the law, or you would interpret it for your lower officers about the procedure for applying this piece of law? Because despite the already accepted resolution of the Presidium, the practice remains the same. First of all, let me thank you for your question. Everything decided by Supreme Courts, Oksana Yurovna and other judges, will not only be translated to the lower level bodies. We will always do that. Any case of cassation or whatever, this is what we send off to the lower bodies for them to follow. The practice must stick to what the courts decide. And we need to learn on mistakes, including our own mistakes. As regards the judicial practice, Oksana Yurovna said, we still make a lot of mistakes. But you mentioned a very good date, 29th of February this year. You remember, it only happens once in 4 years. But we lose about 15% of all cases, so that thing happens only once in 4 years, and that makes us that we do not make mistakes even once in 4 years. We try to improve. So my answer is affirmative. Let me also add, knowing this process has revealed a number of problems, because various decisions were made and the truth only came into being on the 29th of February. It took a long time to reach the truth. And the problem was also about unfair conduct of the anti-monopoly body, who didn't understand correctly the pricing policy. And here you have a new problem, maybe going beyond the antitrust regulation. We fully accept the position of the Supreme Arbitration Court, but we see there is a problem in pricing as well. Yes, please. Good afternoon. Please give your name. Associate Professor for Commercial Law, St. Petersburg State University. I have a question about law number 223 of 2011 about procurement of goods, works and services by certain legal entities. This is to create a field for bona fide competition. It has Article 3, which states, let me quote, and then a question. A participant is entitled to complain the actions of the customer in the process of procurement with the anti-monopoly body. The law is in force and we must follow it, but the procedure is not there. And secondly, what does FAS think? That is it correct for the FAS to establish a procedure for itself to follow? Because all other laws on advertising, on state order, on protection of competition, the procedures are established by those pieces of law. I do not question the bona fide approach of the FAS itself, but is it not an abuse of some legal principles? We didn't want it to be so, you know. We want the government to do that. But the Ministry of Economy was in a great hurry. So these rules are with the Ministry of Justice for registration. But the key procedure is, as per Article 18, it's not only about land or other resources, it's also about the procedures. We keep saying it should be up to the government, but everybody knows that enacting in law is easier and faster in this country than having a government resolution out. If you want the government to do that, I'm totally in favor of that. Grigory Chernyshev. Good afternoon, colleagues. White & Case International Law Firm. A follow-up question about what Mr. Tanner was talking about. He said it was very important to have informal cooperation, collaboration between various agencies and regulators. Let me support what Igor Yurevich said. It's better to talk to someone for 3 hours than to read 100 books. And I think for enforcement in this country, informal networking and communication is of topmost priority. But if you look at the enforcement practice, if you look at the approach currently used by courts when sizing the damage, then we'll understand that private lawsuits in Russia are practically impossible. There's no private lawsuit following the size of the damage is not possible to determine with great precision, because it is customary to believe that sizing the damage in a private lawsuit is based on a concept of economic simulation. What an economic situation would have been if there had been no violation or abuse. And if you use this kind of model in a Russian court, they won't understand you and they would reject your lawsuit. Whereas the European Commission has been trying to address, has addressed this for years, and their website contains a 150-page long document to size the damage with an analysis of economic concepts. I think it would be extremely important for us to discuss this. It would be good stimulus for developing private lawsuits in Russia, private litigation, or unfair competition. Europe has many things that we don't have. It's better to talk to professionals for 2 hours for that you may not exploit somebody else's product. Yes, you may. No, you may not. For instance, there was a car with open doors depicted in advertising, and there are some guys drinking whiskey, and that was a whiskey commercial. And the manufacturer of the car went to court. There was no trademark, but the outline of the car was so easy to recognize. And they in Europe have a practice of how to use that. I tried to do something similar about commercials on Maggie and Knorr. I tried to do that in a court in Moscow. I told them the story, and the judge responded by saying, "But what was the damage? Was any real damage done?" I still hope that that case would be properly decided by the Supreme Arbitration Court. But my question goes to everyone here. What kind of channels or methods or tools or venues should be used for informal communication? Because first things that comes to my mind is conferences. Maybe not generic conferences, but conferences focused on more narrow topics with involving judges from Russia and from other countries, with involving regulators. What do you think? What kind of forms this informal networking could take? Let me apologize. At 12:15 or 12:20, I have to leave, so let me speak now. What we didn't have before works out finally now. We recently talked to car dealerships, and we asked them, why do you behave differently in Russia as opposed to Europe? And what's the point? They say, and we called the European Commission and we compared the practice. It took some couple of hours. Of course, we had formal documents, but informal communication helped us a lot. And we said, okay, why don't you guys consider Russia to be part of Europe, and why don't you behave in Russia as you do in Europe? Otherwise, you would be threatened with fines. This is doable. And if I write a letter, make a phone call to asking what they do in Europe, I'm certain I will get a very detailed answer. We worked like that with Americans and Europeans, Italians. So what I would suggest is, why don't we do something similar to an international journal? It could be a web publication or whatever. Some existing publications could be used in order to generate new concepts. Let's say 10 key differences of the European legislation from what we have in Russia nowadays. Legislation and enforcement. We're quite able to understand what they talk about now. And if we have a special edition or a page in a well-known journal, and if we ask our European or other colleagues to ask our questions, we'll get best of possible questions. This antitrust world is really narrow. This is a small anti-monopoly world. We've started doing joint investigations. Little was said about that. Little has been said so far, but we've started doing that with the Americans, for instance. Thank you, Igor Yuryevich. Maybe some other panelists would like to comment on that. Mr. Tanner, would you?
1, 2, 3. Okay, now it works. Only when some additional remarks. Don't believe that in European Union or in Austria that we understand every decision the court makes. We had 2 years ago with a big cartel. We detected a big cartel in the freight forwarder sector. We gave it to the court. And court waited 11 months without discussing the case with us. And then court decided in favor of the freight forwarders with, I think, 50 or 60-page reasoning. And the reasoning in our position did not fit with EU legislation. So I didn't really understand the decision of the court. And when mass media asked me what I'm saying to this decision, I said my opinion public. And I said it's not good decision. I do not understand it, and it doesn't fit and compare with EU law, in my opinion. It's now a pending case at one of the European courts. So don't think that we don't have these problems too, of course. And I think the value of cooperation also in the informal sector is a bigger one than in the formal one. Because I think what necessary is to find solutions for the problems. You can discuss for months and years some problems. This doesn't help either the authority, nor the undertaking, nor the company. And I think one key issue, if you look at the general topic of the meeting here is, if you look at civil society, and one general key issue is transparency. We have always also to explain our work. We in Austria made a lot of repression in the last 2 years with, I think, 25 down rates in 2 years. But one result of evaluation is that we also have to explain competition law, Austrian competition law and European competition law to the business community. And this will be one key aspect in the next time for us, beside a lot of bilateral cooperation and in the sense of learn from each other. I think this is the key issue, is transparency.
Спасибо большое, господин Таннер.
Thank you very much, Mr. Tanner. Oksana Yurievna would like to say something. Thank you. I'd like to second other people's opinion that forms could be different. I mentioned the conference to be held by the Supreme Arbitration Court with the participation of judges from 6 countries, judges considering the competition cases. In responding to part 1 of the questions, I don't think it would be incorrect to say that what happens if I go to court? Have you tried? You tried only once. You shouldn't expect to be successful from the very first time. In Europe, in America, this has been a widespread practice. It's only nascent in Russia. You are practicing lawyers and you think, and you are talking about what you expect to have from us. Why don't you try first? Let's look at the outcome. You need to apply efforts to make it happen, otherwise nothing would happen. And as regards forms of communication, the federal anti-monopoly body has held many conferences in collaboration with American counterparts, judges, prosecutors. Yes, it is an annual conference now, and when it was held for the first time, when they invited us to participate and speak there, they said something like, why don't you come and hear how things are all right there, where it's not so difficult to prove things in court. And the first conference I attended was when American colleagues were saying, what are you talking about? Proving an anti-monopoly, proving an abuse at an American court. It's so difficult. So don't expect a quiet life anywhere. We need to try. We need to try. Thank you very much, Oksana Yurievna. Alexander Yermolenko, FBK Pravo law firm. I'd like to ask a question or discuss the enforcement powers of the FAS, because in order to do your work, you obviously need to have some powers to this end. And the law, the Competition Protection Act, does provide you with these powers. But identifying abusive behavior, unfair competition, doing that is very difficult if you only do it as an off-site inspection, because cartels are seldom formalized on paper. So you need to try to identify such abuse, and you need to take operative measures for that. You need to do search, interrogation, phone tapping, perhaps. And in better developed economies, in the jurisdictions that we try to emulate, that must take place, I believe. And I'd like to ask, first of all, about what are the prospects for the development of the anti-monopoly service here? Are you going to have, I know you already started, we already started to discuss that. Are you going to have your own investigators to do that? And secondly, what may be the most important thing for us practitioners, if you have those powers, then there must be some procedures in place, some procedural norms and guarantees. Similar, resembling the same in the criminal area, with serious sanctions, with a potential situation where people go to jail. In such serious cases, serious guarantees must be provided. What do you think about that? Look, what is effectively a search, we need that to retrieve documents. You can't fight cartels without that. We do have this power, but I don't think that's any specific power of special services. Those would be working through agents, surveillance, phone tapping, and there's no way other than working with the police. We'll never ask to have such authorities for ourselves, at least anytime soon. We know how to work well with the police. We have actively collaborated with them. We are entitled to read those documents and include those in our cases. It was mainly legalized last year, so specific powers, special powers, should not be ours, because that would threaten the businesses and a lot of harm could be done. And secondly, FAS would become a very different organization. You understand what I mean? We would be one of the enforcement bodies, but I wouldn't like to be one. No one is lobbying for that, I assure you. Formally and informally, we are against that. For exactly this reason, we want to be what we are. But this enforcement component will be strengthened not by adding powers that become to the special forces, you know. We're going to remain economists, but well-trained economists. I have to leave now.
I should like to thank you, but regarding the process, my colleague will finalize the presentation. You know that we have the new rule in our legislation, and we have sometimes, well, the courts send back the cases because we talk about, and we have now the so-called the understand, the twigs. And as far as the process is concerned, with your permission, I should like to extend my thanks. A very, very minor question. I am a member of the Scientific Council on Intellectual Property, and I was very happy to hear that we have lots of perspective in the development of intellectual property. When will you start your first section, and are you going to attract lawyers and economists? Yes, we started with the study of the European practice, and we will be very careful in all our deeds, and we will do it transparently together with the scientific community. It is very important not to bring harm to anybody. If we do some if our steps will not be very delicate, we will not lead to a successful solution. Thank you very much again. It's a pity that you are leaving. As far as the procedural norms, we tried to expand the law about the competition, and there are some new articles, for example, 294, and they concern the searches. And if we are talking about the ORD, we do not have any other norms. But with the transfer, yes, we do have a problem with the antitrust law and procedural law. We do have the opportunity to transfer the duties, but we don't have the real tools. I think that will be solved by the courts in the very near future. So we have a legal problem in this field. So, dear colleagues, other questions? Company BP, Eugene. Unfortunately, my colleague, Mr. Voivodin, has left, and now my question goes to you. Evgeny mentioned the extraterritoriality issue. And I'm very interested in this aspect. When something is happening beyond the territory by the foreign companies, for example, I work for a foreign company, and it has a reflection and influence on the Russian Federation. And as far as I understood from what Yevgeny said, it takes place and we need to do something. Yes, I know that we need to do something abroad if you want to be a serious competitor of the Russian Federation. But my question is, are you going, or how you are going to establish a border where all the legal actions which will not breach the corruption, they can be considered as a breach of the competition law, and these deals may cause some issues, some problems for the Russian Federation. How will you define what is the definition of competition, of the concentration? What are the limitations of the competition? I mean, so that these actions should be less significant. Are you talking about the deals of the economic concentration? Are you talking about other acts and actions? No, I'm talking about other acts and actions. I want to understand because, this question has no limits. Since Evgeny left, I will try to be his substitute. And we have a formal way, a formal method how to use the anti-corruption law, and then we have an informal, a very wide possibility. The first method goes for the economic concentration. We have some figures which can define whether this deal corresponds to the Russian legislation or not. If the foreign company supplies commodities and goods for the amount of 1 billion rubles a year, then with the purchase of a major company or by a big company, this deal has to be agreed upon. Secondly, we can calculate the assets and draw the conclusions whether it limits or doesn't limit the competition. The Russian lawmaker already said that we have to come and see. The second case is when the foreign company comes to the Russian market and they define their behavior abroad. Sometimes we witness the situation when two major foreign companies, they come to the Russian market, they want to establish a joint venture, but before the third anti-monopoly law was adopted, it was considered as an international cartel, and we couldn't do anything about it. But now we have some exceptions when the companies who come to the Russian market, they can conclude their agreements with some limitations of their competition, but the efficiency for the Russian market will be higher. When we give our permission for a merger, it can be considered again as a cartel, and we agree for many deals which lead to the number of the Russian subjects. But these borders, they are pending some economic analysis. Today, my colleague were talking about the proportion of economics and law, and it depends on our abilities how to use this law. We always draw conclusions, and the courts, the judicial practice, they always correct us. And if we say that there is a limitation of competition, and in fact there is no limitation of competition, then our judicial bodies will correct us. Please, could you tell us briefly, a lot has been said about the proportion of corruption and the competition. So if we analyze the model competition against corruption, what would be the main points? First of all, it is practice. We have norms, the legislation is working, and we are gaining experience. What should be done next? Secondly, thirdly, Secondly is the use of law. Third is the use of law. And the fourth is the use of law. This is my reply. Yesterday, I liked the presentation of the chairman of Superior Arbitration Law Court about the proportion between the jurisdiction and competition. And I think it is better, we better may see that if we follow the antitrust law in Russia, we are breaching the antitrust law in US. But I think that with the correct use of this law, we can avoid this issue. And if the company has all the reasons to refuse the deal with the corruptioner, I think that this is a unique law in Russia and in US. But who is this corruptioner? How can we define this corruptioner? This is the big question that we have to give a reply in the near future. I think that we need the definition not only of the antitrust bodies, but we need to know the judicial practice. When we were talking with our American colleagues, they said that a corruptioner is a person who is suspected due to the reasons unknown in fulfilling the corruption. It seems that he's a corruptioner because he has sly eyes. But if we use this practice in Russia, then we may forget that we have the 10th article about the competition. We need to find a correct approach. First of all, in order to secure the law enforcement, and then we have to provide conditions for concluding the agreements. I think that in the next year or year and a half, when we will have not only our antitrust law, but also the judicial practice, we will be able to answer this question. I should like to ask a question to my foreign colleagues. When we were talking about this private litigation, what is interesting, what are the main problems between the courts, between the legal system and the private person? I think that anyway, depending on the refining of these practices, I think that nevertheless we will come to the problems. And Michael Grenfell has said that the activity, the actions, can have a different effect and efficiency, because one part of the companies can enlarge the efficiency, and others they serve as an outsider. But anyway, in the European community they are compared. I think this question goes to Michael.
James, who practices in the courts, will want to add some things. I think the first thing to say is that the point I was making in my presentation about the role of courts is clearly they are important, but their purpose is slightly, but I think fundamentally, different from that of the competition authorities. The competition authorities act on behalf of the public, and their objectives and their priorities are public objectives and priorities. Private litigation, even over competition matters, is on behalf of a private person or company, and that private company's objectives is to get compensation or protection for the company concerned. And while there may be overlap between that and the public interest, they are not identical. In terms of issues which are being faced as private litigation grows, there are several of them. One is when there are at the same time proceedings in the courts and in the competition authorities, should one wait for the other to be resolved rather than going in parallel, because an answer in one may be relevant to an answer in the other. There is a huge difficulty which both the UK authorities and also the European Commission is looking at in how to encourage collective actions or class actions. And the issue there is that given that competition is about protecting consumer interests, when there is a cartel or anti-competitive behavior that raises the prices for consumers, how do you encourage, how do you create methods to compensate consumers without putting consumers in the position that they incur big legal costs, without also leading to a culture of absurd litigation where almost everything is sued, and that has a huge inhibiting effect on business, and there are whole issues about whether in a class action the norm should be that all consumers are acted for unless they opt out, or whether consumers must consciously opt in. And then there is a huge issue, and I think this is the last point I would make, about where a cartel has caused the prices of an intermediary, let us say a distributor, a cartel between manufacturers has caused the prices paid by a wholesaler or distributor to rise. But if that wholesaler or distributor has passed on that high price in high prices to the retailer or to the end user, why should that intermediary be compensated when it has recovered its loss? That in English they call that the passing on defense, and there are great difficulties about working that through. So those are some of the issues. I don't know whether others want to comment. I imagine, James has greater expertise than I in this. So.
Спасибо большое, Майкл. Я просил бы...
Thank you very much. I should like to ask James to make his comment.
That actually quite comprehensively. I think the first thing to say is actually, possibly contrary to your expectations, this is still a very young area of jurisprudence in the United Kingdom, compared possibly with the United States. But as the judge has already said, actually, in the States, as anywhere, it is very difficult to prove from a standing start a competition law infringement, whether that is a monopoly abuse or a price-fixing cartel. What the US cases have traditionally been are what we're now calling follow-on damages cases. In other words, there's something the authority has already investigated and reached a conclusion on, and the damages cases are parasitic on the work of the authority. And that is an entirely different type of case. And we have that in the UK, that if you have a European Commission or a national authority decision that has been unsuccessfully appealed or has not been appealed, so it's become definitive, then you can take that as your starting point. Actually, most cases in the cartel field tend to be hybrid because people are relying on the authority's decision, but also trying to say, well, it went on for a bit longer, or started earlier, or involved more people, or something like that. So there's a sort of mix and match of those, but that's a starting difficulty. We're facing a lot of preliminary issues over the jurisdictions in international cartel cases. Why should you bring your case in London if you're trying to claim damages for all the harm that the cartel has caused, say, in Europe? So there are lots of cases that are, where the argument is about legal issues, such as the jurisdiction of the court, the proper law of the wrongful act, the tort. These are all coming up. And assuming you get through all that, then you have the difficulty that your neighbour raised of actually, how do you prove loss? Or indeed, have you suffered any loss? Because firstly, you have the pass-on defence. If actually, yes, you paid a higher price, but you just increased the prices to your customers, then maybe you have suffered no loss at all. And that's an issue that is very live. in the consultation, which we've mentioned on improving access to courts for victims of anti-competitive practices, one of the proposals is that there will be a presumption that if you have a price-fixing cartel, there was a 20% overcharge, so making it easier for people to prove loss. Now, I doubt that will be acceptable to the British legislature, because the principle basically is, yes, you should be compensated, but compensated for your actual loss, not some theoretically presumed loss. But that is also a very live issue. And mixing the issues of public and private enforcement that Michael has carefully outlined, there is also a live issue as to whether you can claim not only compensatory damages, but exemplary damages, which are designed to be a mark of society's disapproval of the act and to deter and punish. And those are all live issues. So I think it would be wrong to think that across Europe all these issues have been solved and you've just got to go and find them. I think as the judge says, you've just got to keep bringing the cases and the jurisprudence will develop.
Спасибо большое, Майкл. Пожалуйста, вопрос.
Thank you very much, Michael. And the next question. Natalia Kurbanalieva, Head of Legal Department, Department of Transportation Assets. I have a question with regard to the foreign investments. We have a practice of concluding the deals with foreign investors who buy indirect ownership over the holding, which has a strategic meaning. But in the Russian practice, I think that we do not have any legal structure according to which at the bottom, we have this strategic community with a strategic meaning, but the Russian legislation does not have any rights to fulfill the enforcement with regard to this strategic community. What is the position, what is the opinion of the Federal Antitrust body with regard to the enforcement of these agreements, and what is the responsibility of a foreign investor? And these deals I don't think probably they will deter foreign investors from Russia.
Let me take this question. As we discuss a limitation of investments in particular sectors, they are only explainable by two things: taking care of sovereignty and security. That's why the number of such enterprises, the number of such enterprises is not long. It's not a Russian invention. The US and European nations also have a similar approach. There are areas closed for foreign investors. How it could be done, maybe that's a correct thing to say, to ask. If we have a foreign investor through too long a chain, would they care to make amendments to the charters of a dozen or several dozens of subsidiaries to make them let them do it? I think if an agreement is in place that would facilitate things, that is quite doable, but the procedures already established must be complied with. Let me use the panelists try to ask a question to other panelists. It was mentioned before, but not in a focused way, the way I would like to see it. In the Russian legislation and enforcement, I'd like to ask this question to James Flynn, I believe, first of all, and other Europeans. He talked more about this. Does it always happen that it is an antitrust case if some damage has been done to the consumers? Or it's only about the adverse impact on the competitors? Can you make complaints against any seller, or only those players, or only those who are dominant in the market? Thank you.
Well, as a matter of theory, certainly the European competition law and the national law is aimed at promoting the system of competition, and is not aimed at promoting the interests of individual competitors. Clearly, there are times when these may or may not overlap, because, say, a small producer of a downstream product is dependent on a big producer of the upstream product, and possibly in competition with him in the downstream market as well. And that small producer may be at that time may be the only rival. So, in the downstream market. So you do find cases, and I'm thinking Michael will know it, the case of ECS and AXA. You will find cases where what the authority seems to be doing is that was an EC case a little while ago, but seems to be assisting a particular competitor to stay in the market. But in principle, that is not what the laws are aimed to be about. It has been a charge of the US authorities on occasion that the European Commission in Brussels takes a different view from the way they do, say in a case like Microsoft, because they are interested in protecting the interests of competitors. The Commission's answer to that usually is we look to see whether the practice has an effect on the system of competition, and that means that there has to be the prospect of effective competition remaining in the market. And to do that, we look at the situation of those who are actually there, because they provide the best evidence of what can happen and what will happen in the future. So, say in the Microsoft case, the Commission attaches importance to the future of Novell or the open source producers. Whereas the US authorities said, well, it's all fine. The practice is not one that's designed to exclude. So there are differences in approach, but definitely it seems to me that it's what you call a sort of growing pain. It's something young authorities tend to do, is to protect competitors over the interests of competition as a whole, and it's usually something that they grow out of, if I can put it that way.
Я прошу прощения, возможно, была какая-то немножко...
Maybe there was a mistake in the translation of my question. I was rather asking not about the rights of other competitors, but I was talking about consumers. If there's a damage done by a seller to a buyer or consumer, if there is no restriction to competition, could that case be considered an anti-monopoly case, asking for damage? Or you must have simultaneously infringement on the consumer's rights and limitation and or restriction to competition?
Terminological difference between us. I did understand your question, but the idea of the rules that promote competition, the idea underlying promotion of competition, as Michael said, is that leads to effective outcomes for consumers. So you don't necessarily have to show to establish an infringement that particular consumers have been harmed. You look to see what the effect of the practice is likely to be. If, on the other hand, you're talking about damages cases where people are actually suing in the civil courts, well then of course they have to show individual harm to them as a result of the practice. But the practice has always got to be assessed against a standard, a legal rule that is itself designed to ultimately promote the interests of consumers. But not in the sense of consumer protection law, but in a belief, right or wrong, that free competition is produces the best outcomes for consumers. And certainly the authorities in Europe put the interests of consumers will be in their mission statement. That's kind of what they think they're doing, one way or another.
Спасибо за ответ. Просто.
Thank you. Because this FAS is very effective, it often happens that consumers incur damage and that they go to the anti-monopoly bodies. The number of such cases is growing, and anti-monopoly bodies would not always prove violation of competition, because in Russia we also have the Consumers Protection Act, and that can be also used for trying to collect damages for any violation. That hence my question. Thank you, Oksana Yurievna. Thank you, James. Well, we have to wind up. We can take two more questions. Yes, please. Dmitry Gilep from Lexi Bank. My question relates to the newly enacted Act 223 on procurement by certain legal entities. I'm asking about the implications if this law is not complied with by those who are responsible for procurement, for the counterparts, because this law is applicable to a wide range of entities who may provide their own rules for making procurement. On the other hand, the circle of such entities is so wide that it is not always easy to understand who really is subject to this particular law. You can't understand that before you've identified precisely the ownership in this entity. And for us as a bank, there is a key issue, a key question. Can we invalidate a contract that was made without following the procedures as per this law? Strangely enough, the procurement procedures to be established by the legal entity itself, it has a status of a legal act. Strangely enough, a legal act, as follows by its name, should be something that is enforceable by the state. Would it not happen that a legal entity, that it is not obvious for the bank if a legal entity should comply with that law, and if it enters into a loan agreement, for instance, and then on the initiative of the legal entity itself, or maybe through the anti-monopoly body, that contract would be questioned and they would try to cancel it? Well, implications would be a derogation of the contract. It follows from the anti-monopoly law and this law you mentioned, 223. As regards the legal implication for the counterpart, who maybe was wrong about the interpretation, the civil law provides for the possibility of exacting damages from such things, that's the only way. On the other hand, the law 223 doesn't clearly stipulate that. This is an information law. You first need to announce the procurement procedure, and then we'll judge you based on what you did. That is not really good. Maybe someone else would like to comment on that. Please use the microphone. But there's the civil code, and invalidation of a deal must be taken from that. Why don't we start applying the law if there are grounds? I think the question was not entirely, correct, I would say. Please use the microphone if you want to be translated. In this case, there could be not a direct violation of the law, because procurement procedures must be followed according to law, but procurement could be done not in line with the procurement procedures as specified by the procuring agency itself. Can this contract be invalidated? That depends on the evidence you provide. Article 17 on the Protection of Competition Act, it has provided for the last 17 years exactly the possibility you mentioned. A contract could be derogated. What about IPR? My question is to our European colleagues. How important do you think the anti-monopoly regulation of the IPR as one area in the activity of the anti-monopoly body, does it have any influence on the development of competition in innovative sectors? And given what Igor Yurievich was saying, that such regulation must be done in a very cautious way, could you already now formulate some caution to us? Could you forewarn us about some mistakes that we could make? Michael, please.
I think you raise a very important question, and the debate about the balance between competition law and intellectual property law is a very, very live debate in European competition law, and you should not think that it is settled, but it has come to life in some of the cases we've been talking about. We talked about Microsoft, where it came to life. It is absolutely live in the whole host of disputes before the courts and competition authorities around the world about smartphone patent rights between Apple and Samsung and so on. And really, the issue is that in some ways, competition and intellectual property have the same objective, but they point in different ways. Competition essentially seeks to encourage innovation and new and better quality through exposing people to competition. Intellectual property rights seek to encourage innovation by rewarding the innovator and protecting the innovator from competitors who might free ride on the innovation. So one is about encouraging innovation through exposing to competition, and one is about encouraging innovation through protecting from competition. And I think in Europe and elsewhere, competition authorities have been very, very, very conscious that although there are times when competition law needs to override intellectual property rights, that needs to be very, very carefully done, and it mustn't go too far, and there must be proper respect for intellectual property rights. Now, just very briefly to say how it has developed in European competition law, effectively, the European authorities have developed something which is very similar to the essential facilities doctrine, which they applied to the privatized infrastructures of the utilities, so that just as for a gas pipeline, where there is only sort of one gas pipeline, the owner of the gas pipeline is to some extent obliged to allow competitors to have access to that pipeline, or the owner of a single national telecoms network is obliged to allow competitors to have access to that telecoms network. So there has been a sense that with intellectual property rights, where it is essential that competitors have access to those rights in order to compete, equally there is an obligation to give that access. But of course, in doing so, that very much weakens the protection offered by the intellectual property right. So in the Microsoft case, and in a previous case called McGill, and in a whole host of other cases, the European courts and authorities have allowed have said there should be an obligation to have access to intellectual property rights, but only in very, very limited circumstances. And basically, it is first where access to that intellectual property right is absolutely essential to competition. Second, where, and it's more or less the same thing, where without it, there would simply be no competition. And thirdly, and this was the Microsoft point, where either not having access stops a new product emerging, or, as was said in Microsoft, at least stops the development of a technology. So those are three quite strict criteria. Where those criteria are met, competition law will override the intellectual property right, but they are strict criteria, and there is a very, very difficult balance to be drawn between ensuring that the intellectual property right does not strangle all competition, but at the same time not so overriding the intellectual property right that there is no protection given to innovators.
Спасибо большое.
Thank you very much.
Right. So it's difficult to it. So we have not really the discussion in this area. We are looking at the developments in the European area, and probably there is, can give you one hint concerning literature and papers. There were working groups in the OECD in Paris, and I think it's published at the homepage and there are a lot of discussions also between the states and the European area, and I think discussion has been finished in Austria. In my authority, we have no cases at the moment. No cases.
Спасибо. Ну и завершающий.
Thank you. And the last question. Нет, не слышно. It's a question to our foreign colleagues, and first of all to Michael. Michael mentioned that in the last decade, the role of economic analysis has been increased. How often the basis for debating of how often the incorrect economic analysis can be the reason for the wrong decision? What do you fulfill? What do you do in order to unify, to make more objective the results of the economic analysis? If time allows, and if Sergei Anatolyevich agrees, I would like to hear from our foreign colleagues whether the decisions supporting or not supporting the decisions of antitrust bodies. For us, it's a new trend, but a very important trend for our business. Our antitrust bodies, they spend a lot of efforts in this direction, working out the regulations and their practice. Well, they're doing a lot, but what happens in your countries?
I hope I've understood the question. If not, I may ask you to come back with it. I think I think the starting point is that everybody recognizes you can't reach competition decisions without having some degree of economic analysis, because, after all, competition law is a form of economic law. The question is, is the degree of it and the degree to which the economic analysis becomes so complicated and so uncertain that you lose the benefit of, as it were, the rule of law. Now, in practical terms, a number of things have happened. On the side of the competition authorities, literally, people who have an economics background have played a bigger role in the competition authorities. If I think about the people who have led the competition authorities in Britain, it used to be they were either old-fashioned civil servants, public officials, career public officials or lawyers, increasingly they are economists, and the current head of the main UK antitrust enforcement body, the Office of Fair Trading, John Fingleton, is an economist by background. But other people, so the most recent or the previous head of the Competition Commission was a lawyer by background. So it's partly that, and then at more junior levels, there are economists and lawyers. And there is now a proposal that to make the Office of Fair Trading's decision-making process on cases involving anti-competitive agreements or anti-competitive behavior, in order to make that fairer, each case will need to be looked at by both lawyers and specialist lawyers and specialist economists. Now, on the business side, it is increasingly a habit that businesses will engage economic consultants as well as lawyers in defending their cases. And in merger control, control of concentrations, particularly, there is a very great deal of economic analysis on the effect of the merger on pricing. There is a move away from, to give one example, in merger control, there used to be a rather crude analysis of defining what the market is, and then what are the market shares and how many players in the market. Increasingly, there is focus on, there's a sense that that is a less black and white issue and more a grey gradual issue, and that some competitors are closer competitors of each other than others. And in order to work that out, a great deal of economic analysis of data is undertaken. So those are the ways, both at the public authority level and at the business, on the business side, economics has become significantly more important in the last decade. But what I was saying in my presentation is there is a little bit of a backlash, to a small degree, to prevent the economic analysis becoming so complicated that there is uncertainty for business and for practitioners. Does that answer the question?
So
Пожалуйста, господин Таннер.
we'll try a short
Mr. Tanner,
took office as head of my authority 5 years ago. I mentioned 3 points, and one point was strengthen the economic approach. After 5 years, I'm not so sure if it was a wise decision, and I will tell you the reason. We have established a chief economist and a team, and if we have big cases, we're making joint teams with lawyers and economists, and it works very well on the one hand. But on the other hand, if we give cases to the court with economic analysts, court also asks experts in economics, and they're writing a lot of papers, and there sometimes I have the feeling that a lawyer or a judge who is educated in law has some difficulties to see all the problems there. And if you think this point consequent, the result would be that judges must have economic education. And there is one, I think, Supreme Court in the world where judges are economists. It's Chile. Interesting. South America. And so I think it was an European phenomenon, this more economic approach 10 years ago. And if I feel it and I see it right, there are a little, Michael described it very well, there are little steps back, and I think it's okay.
Спасибо. Джеймс.
Thank you. Now, James, the floor is yours.
I mean, you know the old joke, how do you get 5 economic opinions? You ask 4 economists. Is the Microsoft decision right or wrong? People can reasonably disagree about that. And as my colleagues have described, no case now happens without economic advice, or no real competition case happens without specialist economic advice for each of the parties and the regulators. And in my field, which is the consequent litigation, when you're taking these cases to court, you face precisely the difficulties Mr. Tanner has said. The judges, on the whole, are not specialist economists, and why should they be? You know, they're deciding lots of cases about personal injuries, medical negligence, you know, sort of all sorts of areas in which they're not experts. Why should they suddenly become industrial economists as well? And I think there is a big danger of this becoming a sort of little field that only certain people can understand. And I literally saw in a case recently an appeal against a decision of our broadcasting regulator, where one of the main questions put by the Broadcasting Regulators Council in court to certain bodies who were affected by their witnesses, the first question was, are you an economist? And the implication is, if you're not an economist, you can't understand our decision, and therefore your evidence as to what you think the effect of this decision on your business will be is valueless, because you simply don't understand. Which is an extraordinary development, and I think it's a difficult tension, because we are applying economic law, and you know, good economics is at the basis of it. But how to decide the economic issues that arise and give people an appropriate margin of discretion to make regulatory decisions is a very difficult issue. And how judges in damages cases, for example, recently I was doing a case about a local bus company, the incumbent city bus company, priced abusively to exclude a new rival. And the whole case really turns on the counterfactual. What would have happened if they had not made this abusive pricing? So the new entrant could have stayed in the market and made some money. How much? How many people would it have taken? What prices would it have charged? All that is a matter for economists, and this is extremely difficult material for courts to deal with. So it's a problem we have, and there's no obvious solution, I think. The economists are here to stay, and so they should be, but it gives rise to some real practical problems in deciding cases.
Спасибо большое, Джеймс.
Thank you very much, James. I think that the questions that we've discussed, they open new horizons for us, not only in the field of the use of the law, but in the thinking of the new initiatives. And I should like to, with all my heart, I should like to thank all the speakers who delivered their remarkable presentations. I should like to thank all the participants who raised interesting questions and provided for the outstanding interest to the roundtable discussions, because the questions that were raised, they led to other questions, and I know that next year we will have a lot to talk about during the 3rd legal forum, which will take place here in St. Petersburg. Thank you.